On Monday, Nigeria's appeal against an $11 billion bill for damages started in a London High Court. Nigeria's lawyers have told the court that Africa's largest economy was the victim of a campaign of bribery and deception surrounding a failed gas processing project. This appeal stems from a London arbitration tribunal awarding Process and Industrial Developments, otherwise known as P&Id, a little-known business with headquarters in the British Virgin Islands, $6.6 billion in damages in 2017 for lost revenues resulting from the failed project. With interest, this has now swelled to just over $11 billion, or around 30% of Nigeria's foreign exchange reserves. The country claims that the 20-year contract awarded to P&Id in 2010 was procured by bribes paid to senior officials at its Ministry of Petroleum Resources. Joining me now from London is Tolu Aderemi, partner in the law firm of Perchstone and Graeys, with specialization in the oil and gas sector. Tolu, welcome again to Business Edge. Thank you so much for joining me. We're seeing this case 24 hours in, or at least the first day in. And just for those who may have missed the magnitude of the case before us right now, just a quick rundown or run through of where we are and how we've gotten to the points right now in this appeal process.
All right. Thank you again, Tolu. I think this is one of the best times to be proud as a Nigerian. It's never been so good when you attempt to fight corruption at the international stage. And I think this is exactly what Nigeria is doing. So kudos to the president and, of course, by extension, the Honorable Attorney General. Now, by way of summary of what has happened and where we are, it's a simple case of a gas supply and processing relationship between two parties or two partners. One partner, a company, I mean, I wouldn't use all the adjectives that's been used to describe that company, but it's just a company. And the other partner is sovereign government. Now, the dispute resolution clause in that document, in that agreement, appears to be what has led to this crisis. Of course, there are bigger issues of corruption, but there was allegations of non-performance on the part of either side in that contract. One party, which is the P&Id company, alleged the federal government had not supplied as it ought to gas procured from OMLs 123 and OML 63, both operated by Adax Petroleum Company. And federal government on its part also alleged that, look, for me to supply the gas, where's the gas processing plant? And so these were, counter allegations, and which went to arbitration, a 3-month panel. One of the things that became a disaster, and again, there are many lessons to be learned in this as we move along, is the dispute resolution clause, which on the one hand, the contract provides Nigerian law as the governing law of the contract. But when it came to the dispute resolution clause, made provision for London as the seat of arbitration.
Yes.
Now, as the chairman of Arbitration Committee of International Law Association, this is one of the things we have been advocating, that contracts that are government-centric, we must ensure that they are not only governed by Nigerian laws, the seat of arbitration, which is the juridical seat. In other words, that is the seat where whenever you need a court support, that is the court of the country where you go to. Otherwise, we have no business being in London today. And so in that contract, London was agreed by both parties to be seat of arbitration.
Okay, Tolu, I want to come in here because you raised a few points, and even the tribunal has come under the spotlight. But when you talk about the contract, having London being the location, it also calls into question the contracting process. And so that's one of the questions I need to ask you now, because when you go back to the beginning, Nigeria and P&Id agree for P&Id to build a sophisticated gas processing plant. It sort of becomes a chicken and an egg. Give me the plant, I'll give you the gas. No, you give me the gas, then you can give me the plant. Sort of that kind of back and forth. But we also know that there's a lot of opaqueness that happens in Nigeria's oil and gas industry, a lack of transparency oftentimes with some of these contracts and some of these ventures, and that's been a criticism of this industry. So when you look at it, people are wondering, how does a company with no technical background or capacity or even experience end up winning a multi-billion-dollar contract in Nigeria. And one of the points is that one of the men at the center of this, Michael Quinn, who unfortunately now is dead, is a former Irish band manager. Doesn't that even automatically raise red flags when you're doing your due process and your investigations? What do you make of this aspect? Because many, as you said, there are lessons to be learned here.
All right. These are very embarrassing points that you have made. And I personally, my firm was involved in about $3.5 billion transaction in the oil and gas industry, which went to arbitration. And some of the things that we saw in terms of the contracting processes, in terms of understanding, and so you see, sometimes it may not be outright corruption like it's being alleged. Sometimes it's putting square pegs in round holes. People who do not understand, because to be honest, I utterly don't understand why you will have London as a seat of arbitration, and then you have Nigerian laws governing that process. And I think we shouldn't dwell on the past. Like I did say when we started this conversation, it's a beautiful time to be a Nigerian. Nigerian has identified, and everybody needs to read that 43-page judgment of Lord Ross Craston,
yes,
who sat, as a judge of the Queen's Bench at the time. And you will see that that document reveals the quantum, the wanton, and the irresponsible corruption that went in the course of this, of the procurement of this transaction. So I will be belaboring the point, if I were to start explaining to you that our contract procedures and processes, are faulty. Under the current administration of the NNPC Limited, a number of things have been corrected. And you will tell that part of the consequences of that correction is what we are dealing with, in the, I mean, for the first time, or maybe one of the few times, Nigeria is coming out to say, no, you can't take a third of my budget. 11 point something billion dollars. It's about 3 point something trillion naira. That's a quarter of Nigeria's budget. You can't take that. And I am saying that I am alleging wanton corruption in respect of senior government officials, in respect of lawyers who represented me as a country, and in respect of other private individuals. And I need to come and put my case before the English court, who anyway has the jurisdiction to hear me. Let me make a point. And I think it will be good for Nigerians to know that as it relates to the arbitration award, we have no case there anymore. That must be made very clear. How that matter was handled was a combined, not incompetency, but again, how government handled. I mean, we understand at the point under the former Attorney General or so, they were reluctant to release documents to counsel representing the country. I mean, those are bizarre things to hear of. And so, as it relates to arbitration award, we're done with that. However, what Lord Craston did, and I think it must be commended, was that he did two things. On the one hand, he decided you have no case as it relates to this award. Does it mean that Nigerians, or as a party, you cannot review? Of course, you can review an award, but within a certain timeline. Again, we lost that timeline. So we did not put in an application to set aside that award. However, we were smart enough as a country to bring in an application. I call it the Section 67, Section 68 application under the British Arbitration and Conciliation Acts of the UK. And what does that provision make for? That a party can apply to set aside an award where there's substantial injustice or substantial irregularity. That was the window that we had.
Okay.
And we were able to demonstrate, and I'm very optimistic, to be honest, that the outcome of this 8-week trial will be in favor of Nigerian government. Because when you read that 43-page judgment, you will see that Lord Craston almost decided. I mean, for a judge to say, look, and there are two main issues Nigeria would grapple with. One, that there was a project that was procured by bribes paid to insiders as part of a larger
so the
scheme.
Foundation is already faulty.
Absolutely.
Yes.
And then secondly, that one of the owners of P&Id gave perjured evidence during trial.
So, Tolu, let me come to that owner, who unfortunately, again, as I said earlier, is dead. Michael Quinn is the person that you're referencing there. But there's an interesting aspect that I found when looking through the documents. He used to manage bands in Dublin in the 1960s before he transformed himself to an industrial consultant for projects in Nigeria. He died in 2015. But court filings submitted by Nigeria say that the company he co-founded is now controlled by Lismore Capital and VR Advisory, which is a hedge fund that specializes in distressed debt. And many have pointed out that P&ID is now backed by what is described as a powerful international vulture fund. These type of funds have a record of exploiting vulnerable countries. So, Tolu, that's a point I want us to sort of dig out from under all the paperwork and all the legal sort of conversations. There are funds that exist to go after such cases as the one that Nigeria is facing with P&ID in order to go and claim debts and distressed debt. In terms of that, why do you think it's important to note? I know why I thought it was important, but from a legal perspective and one that looks at this case overall, why do you think it's an important thing that we should keep our eyes on?
Why is what important?
The backing, the hedge fund that is now backing the case against Nigeria, or the type of hedge fund. Let me use that, yes.
Well, I think those will be taking us to a realm of speculation, to be honest. I mean, you could argue it in both ways. One way is the way which you have argued it. Another way could also be third-party funding, which is by law in the UK, and the Nigerian Arbitration Act is also, we're also making provisioning for it somehow in the Arbitration Act that is currently being amended. So to be honest, we could start making conjectures as to why the company has been taken over. Quinn is dead. And like you rightly said, you know, he was a bandman. Those points, to be honest, they really are immaterial. What is material, which is the second point that Nigeria will have to demonstrate, you know, in this London court, is the fact that evidence was led during trial, during oral hearing, I beg your pardon, before the tribunal, that P&ID company had the capacity to deliver on this project. And he did not do so. Now, he also made witness statements. He gave witness statements, which on oath will now be perjury. So these are the strong points that the Nigerian government is holding on to be able to establish that there was criminality, or that the arbitration award was tainted with criminality, and for those reasons, it must be set aside.
Let me go back to Sir Crankston, as you said. Part of his statement also said this. He said that not only is the integrity of the arbitration system threatened, but that of the court as well, since to enforce an award in such circumstances would implicate it in the fraudulent scheme. And that's where I'll wrap up this conversation. In terms of this, it's an 8-week trial just kicking off. There's still going to be a lot more that comes out. But do you also think that maybe the UK arbitration system is also sort of in the spotlight, or the term that some might use is a bit under trial or on the stand in this situation as well?
Well, I will not entirely depart from your thoughts, and I say my reason is very simple. When you look at the award delivered by, I mean, it's not public record, so we can read the award. You look at the award. Why do we have a claim of $6.6 billion for a transaction that never kicked off? I'm sure you know that even the land upon which the gas processing plant was to be constructed was not even being paid for. And then the tribunal, 3 of them, incidentally, the third of the 3 is a Nigerian, in fact, the former Attorney General. And the 3 arbitrators, they agreed that there was a breach of contract. For me, that was troubling. Now, was it troubling because Nigeria did not perform? Or was it troubling because the other part did not perform? I think what the tribunal may have considered would have been the intention of both parties in performing in that contract. And in looking at the intention, you must look at Party A's obligation, because Party A's obligation is contingent, Party B's obligation is contingent on Party A performing. What is Party B's obligation? To provide gas, because it's a gas to power project. Party A's obligation was to construct the gas processing plant. And so the gas processing plant was to warehouse the gas to be provided or to be supplied by the Nigerian government. If you do not, I mean, it's as if you ask me to supply diesel to your house or to your a station and you have no diesel storage tank, or you don't even have a station at all, and then you tell me, Tolu, you need to come and supply diesel here. Where do I supply the diesel to? Now, the problem with Nigeria, and again, this goes to lessons learned from this transaction or from this dispute, is that we must treat business with all the commercial expediency that it requires.
Yes.
The moment P&Id was unable to demonstrate capacity to construct that plant, and you would have seen that from their inability to even pay for the land, you should have issued a default notice. The contract clearly provides for a default notice. And once the default notice expires and the other party is unable to remedy that default, then you go to your termination provision and you terminate the contract. If there's any monies you have expended, you can go to arbitration. And so we as Nigerians must constantly we must be proactive. It's always difficult when you are defending whether in arbitration or whether in litigation. And that is what has happened. That's one. Two.
Very quickly, Tolu, because of time, I apologize. Go
Yes,
ahead.
please go ahead.
Number two. No, go ahead with number two.
Oh, okay, all right.
Yes.
The second point is that the government official who superintended over that contract,
Yes.
to my mind and with the greatest respect, did also not understand the importance and the consequence of the drafting of that contract. And this is where it comes to, when you are dealing with, without prejudging the matter, quacks like those people, or you're even dealing with foreign counterparts who are well experienced, you also need to employ or engage or procure the services of experts.
Yes.
You can't, in the breadth of one contract, have Nigerian law as a governing law because it's perfunctory to do so. And then in the arbitration, a dispute resolution, which is a contract on its own, if everything fails in a contract, and it's a saving provision, if everything fails in a contract, the dispute resolution provision stands and survives it. And in that provision, you say the seat of arbitration shall be in England. You've taken it away from who does that to a sovereign.
And those are questions.
But unfortunately, we have lost the right to do those things. This dispute was resolved on three planks.
Okay.
One was a question of jurisdiction, which we lost because the seat jurisdiction was clearly put at London. The second was liability. We also lost it because the man who brought the claim first claimed that, look, you're liable for not providing me with gas. And that was the narrow point the tribunal looked at. And three was the question of quantum. The question of quantum, and it's a very interesting one because the tribunal started calculating the quantum from the date of the contract was signed. The third arbitrator, who is a Nigerian, former Attorney General, said no. So there was a dissent there that, look, the project could not have started until about 3 months, even after. And so when you calculate quantum, it should have been from that end.
So, Tolu, we know that this case has a lot. It's just day 2 of what is going to be an 8-week trial and one that we're going to be following very closely. We know you'll be following closely as well. So we'll be checking in with you for updates. Thank you so much, Tolu, and I apologize because of the time today.
Thank you very much for having me.